alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I am able to cover a vast diverse range of matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please do feel free to pick up the phone and give us a ring on the number that appears at the bottom of the screen. So giving us a ring live on air is one method of getting in touch. The other method, which is extremely popular with our viewers, is to send us a message on the mobile number, a WhatsApp message or a text message on the mobile number, which also appears at the bottom of the screen. Now, on the show, we always get a vast diverse range of queries coming in. If it transpires that your matter is complex or I need to look at your documents before I can advise you properly, then I'll ask you to leave your number with the control room and I'll have a more thorough discussion with you off air. So even if your query is simple or complex, however complex it is, please feel free to get in touch. If it's complex, I will arrange to speak to you off air and provide you some advice in relation to the issues that you have. And again, it's a service that we provide as part of the free legal advice show and is completely free of charge. And as I said before, on the show, we get actually numerous questions on immigration law matters, spouse applications, visitor applications, nationality applications, which is fantastic. But even if your matter relates to another area of law, it could be a family law matters, it could be a property law matters, I should be able to give you some advice, a second opinion on the issues that you are facing. So two ways to get in touch. To speak to me live on air, you can ring on the landline number which appears at the bottom of the screen. And as always, you can continue to send your messages in on the mobile number, which is also there at the bottom of the screen. Now, even before we came on air today, we had a number of questions coming in anticipation of today's show. So I'm going to start going through the questions that have already come in on WhatsApp. Please do continue to send those in. And as always, please do feel free to get in touch with us here live as well. So let's look at the first question. Immigration law, as I said, is always a popular area. And I see that a number of questions have already come in on that area. Now, first question that's come in looks like it relates to visitor application. So let me read the question out and let's address the question that's been raised. I do apologize. We do have a caller who's our first caller for the day. So let me go to the first caller for the day. Hello, assalamu alaikum. Hello. Let's try again. Hello, assalamu alaikum. Hello. I think there's some difficulty in the call coming through. I do apologize for our technical difficulties. Do please try our landline number again, and our control room will try and put you through here live in the studio. Now, just before we try to get the caller to speak to us live on air, I was looking at the questions that have been coming in on our WhatsApp mobile number, which is there. First question that's come in relates to visitor applications. And let me read the question out and let's see where we are. Our viewer says, Assalamu alaikum. I made an application for my mother to come to the United Kingdom as a visitor. The application has been refused. How do you advise I should address this? Now, look, it's a very popular question. I will come back to this, but let me go to our next caller who's been waiting for a while. Hello, assalamu alaikum. Hello. Hello, assalamu alaikum. I do apologize. There seems to be some difficulty in putting the call through to us. So let me just go back to the question relating to visitor application. So our viewer is saying that the visitor application for a mother has been refused. And what advice would I give in terms of addressing the refusal, which seems to be on the basis that the concern that the Home Office has is that mother won't go back. I do apologize. We seem to have the caller back online, I think. Let's try again. Hello, assalamu alaikum.
Hello, Ilyas sir. This is
Hello.
AJ from Birmingham.
Hello, Assalamu alaikum.
Sir, I have one
Hoping it's
question
third time
about
lucky,
my
but that
friend.
doesn't seem to be the case. So let me go back to our question. So it's a question relating to visitor
Can you
applications,
hear me, sir?
and in particular relating to a refusal and how we can make an application for a visitor to the United Kingdom successful. Now, visitor applications at the moment are particularly difficult in getting right. What seems to be happening at the moment with most visitor applications is that the Home Office seems to be refusing them on the basis that the immigration officer isn't satisfied that the person who's applying will return to their home country. Now, that's the reason for the refusal, that immigration officer is not satisfied that the person has the intention to return to their home country. And they use various reasons to back that up. That they tend to say, look, your ties with your home country are not very strong. So if I give you an example of sort of a typical visitor application that we deal with, it's normally parents who may be in their 60s, maybe in their 70s, wanting to come to the United Kingdom to visit family members here. So mum might be coming, dad might be coming to visit the children in the UK. And when it comes to refusal, what they tend to say is, well, look, you don't have any children who are under the age of 18, so your family ties are limited in your home country. Or they might say that you don't have any income. So financially, you're not very stable. You seem to be supported by family members in the United Kingdom. Or they might say, look, you've not traveled to any other countries such as Europe, America, Canada, etc. You don't have travel history. You've never left your home country. Or they might say that, look, we've looked at your financial circumstances, but we're not satisfied that you're portraying a correct, accurate description of your financial circumstances, because when we look at your bank statements, we can't tell where your income is from or what your expenses are. So there are, in my view, there are a whole host of standard reasons or standard grounds upon which visitor applications are refused. What I would advise is that the starting point is try and spend a bit of time in getting the visitor application right. And it's not so much getting the documents of the sponsor in the UK right. What you should really be doing is getting the applicant's documents, maybe in India, Pakistan, Bangladesh, wherever it is, getting their documents right. So, look at a number of different areas that they look at. Look at the ties with their home country in terms of family that might be in their home country. You need to accurately describe, demonstrate who the family members are in their home country. It could be there are children over the age of 18 there. There are brothers, sisters. There may be grandchildren who are there. So you need to accurately describe, demonstrate, and prove who the family members are that you have in your home country. So establish that there is a family there that you will want to go back to. Secondly, if you look at income and assets, if you look at income, if there is income, for example, there may be income from land, there may be income from a pension, whatever the income is, you need to accurately describe and demonstrate by way of documentary evidence what that income is. So, for example, commonly we come across a situation where the person coming to the United Kingdom will own properties, will own land which has been leased out. So you'd need to see evidence of ownership, maybe evidence of valuation of that land, evidence of the land being leased out, and evidence that rental money is coming into the visitor's bank account. So whatever the income is, address your mind to that, and by way of documentary evidence, demonstrate it and explain it. There may be assets that the visitor holds, such as their own property. You could get a valuation report. They may own other land. You might be able to get proof of ownership, proof of valuation to show how much in terms of value assets that they hold in their home country. So if you spend a bit of time on the application and deal with each different area, family in your home country, income that you earn in your home country, your assets in your home country. You may have traveled elsewhere. You need to demonstrate where you've traveled, to show that you've traveled, you've returned to your home country as well. So these are the things that you do really need to address if you're going to make a successful visitor application. Now, obviously, there are you have the sponsor in the UK. The sponsor will demonstrate their ability to financially maintain you and accommodate you. And if there's a reason why somebody's coming to the United Kingdom, there may be a wedding, somebody in the family might be close to giving birth, so they may need assistance with straight after birth in terms of looking after the baby, etc. If there's a genuine, credible reason, you need to put that forward. And again, you need to back it up by way of documentary evidence. So I completely understand the question that's been raised in terms of, most visitor applications being refused. But there are things that you can do to try and make your application stronger. And my view, what I tend to see is that a lot of applications, visitor applications, are rushed, and a lot of the work that needs to be done to make an application quite strong simply isn't being done. So I hope that gives you some pointers in terms of what you need to do to make the application strong from the applicant's point of view and in terms of the sponsor's documents as well. We've had numerous questions coming in on WhatsApp, but we're close to taking a break. So when we come back from our break, we'll look at some of the other questions that have been coming in. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, if you want to send us a message with your questions, please continue to do that on the mobile number which is also there at the bottom of the screen. Now, we've had a number of questions coming in. Let's turn to those questions now. Looks like they are immigration law questions. Now, I've not had a look at these questions, so I'm going to read the questions out live on air, then we'll try and address the questions. Now, our viewer says, Assalamu alaikum. I would like to ask, we got married in 2015 in the United Kingdom. My wife got a spouse visa in 2017. Her second extension is expiring on the 29th of April. So I was wondering if we could apply for indefinite leave to remain before the 29th of April. As the 5 years will be completed before April, or should we wait for 28 days before the 29th of April? Right. I think the question is this, that wife got the spouse visa in 2017. So there was a slight delay in getting the spouse visa. Original marriage had taken place in 15, but the spouse visa is in 2017. Visa expiring on the 29th of April. Can you apply before the 29th of April if the 5 years are completed? The short answer to that is yes, you can. We get asked these questions quite often. You don't need to wait until your second extension is going to expire. So obviously, when you get a spouse visa, you get the initial grant of two years and 9 months. When you apply for the extension, you get a 2.5 year visa at that stage. Now, what tends to happen is that the spouse who's come to the UK will complete their 5 years before the second visa comes to an end. Now, if that's the case, you can apply immediately when your 5 years are about to come to an end. In fact, you can apply 28 days before your 5 years are completed. Or, if you want, you can wait until your second visa is coming to an end. So you have a choice. So if I give you an example, somebody who came to the United Kingdom on the 30th of March 2017, they would be able to apply at the beginning of March 2022. If their visa expires in April or May, it's up to them if you want to wait. But by all means, if you complete 5 years legal residence in the United Kingdom, you can apply 28 days before your 5 years are completed in the UK. So hope that answers that question. Very, very common question. And what I tend to advise clients is, if you think you're ready to apply, certainly get your application in. If there is some difficulty, for example, your financial documents aren't quite there, the English requirement you've not managed to fulfill yet, you still need to pass the Life in the UK test, etc., that's fine. Then try and get those done. You have until the expiry of the second grant of your leave to remain, so you have a bit more time. But if you're ready, no reason to delay it. Who knows what's going to happen if you delay? By all means, get your application in and you can apply 28 days before your 5 years are completed. Hope that answers your question. I do apologize to our viewers today. We've had a number of people trying to call in. We are having some difficulties in putting calls through. I do apologize for that. We are trying to resolve it, but if it's the case that you do need to ask me a question and you're not able to speak to me live on air, please do send the questions in on that mobile number. We do have some technical difficulties today, so please do send your questions in on that mobile number and I will address your questions. If after I've addressed your questions, you've got follow-up questions, please do feel free to send those messages in. I am receiving the messages as you are sending those in, and we've got a number of messages coming in. Okay, let's go to our next question. I am on the 5-year route. Is it 5 years from first issue, or do I have to wait till the end of the second further leave to remain to apply for indefinite leave to remain, which may be after 6 years due to a gap in waiting for the Home Office to issue the second FLR? I think this might be a follow-up question. So what our viewer is saying, I think it is still to do with the spouse application. They are on the 5-year route to settlement. And what they are saying is that there was a gap. Now, this is not unusual. There was a gap between the first visa coming to an end and the application was I assume was made in time, but there's a gap between the first application, the leave to remain for that coming to an end, application submitted, and the application being processed and the second visa being granted. So obviously that gap, sometimes it takes 6 months. During COVID times, it would take slightly longer. It takes a bit of time for the Home Office to process the application. So it does mean that by the time your second visa comes to an end, you might have spent 6 years in the UK. So I'm assuming it's a follow-up question from the first question. Again, as I said before, I understand that there may be a gap in between. The gap is when the application was being processed. Assuming you're on the 5-year route, assuming you've done everything on time, you can apply for indefinite leave to remain. Once you've been in the UK for 5 years, in fact, you can apply 28 days before you complete your 5 years. But thank you for that. I assume that was a follow-up question, follow-up from the first question that you'd posed. But thank you very much indeed. If you're not sure about the answer that I've given, please do get back in touch with us. Fantastic. Let's look at the next question that's come in. Now, the question is as follows. I would like to know whether I am eligible to take part in the government-funded apprenticeship program based on my visa conditions. My visa conditions say that I cannot have recourse to public funds. Current visa, I'm on a 10-year partner/children route. I'm a healthcare assistant. I work full-time, permanent contract. My profession requires continuous professional development, CPD. I have been offered an apprenticeship course funded by Dynamic Training, which is funded by the Education and Skills Funding Agency, supported by the Mayor of London. Can you please assist me regarding this issue? Basically, our viewer is asking a very valid question, something that I've been asked before. Our viewer's concern is that on the visa, at the moment, it says the condition is that you're not eligible you're not eligible to access public funds. So it'll say no recourse to public funds. Does that prevent you from enrolling on an apprenticeship program? The answer is no. You can join the apprenticeship program. It's not a problem. The reason for that is this, that where it says, like your visa does, no recourse to public funds, where it says that on your visa card, and you're not eligible to access public funds is defined. So public funds isn't every assistance that you may get from the government. Public funds is certain benefits, certain things which are defined, and it is those things that you cannot access. So for example, there is a list of things, for example, universal credit, for example, personal independence payments, for example, carers allowance. So there are specific benefits, specific types of assistance which fall within the definition of public funds. It is those things which you cannot access. So from an immigration perspective, there is no problem. Apprenticeships do not fall within the definition of public funds. So you can, from an immigration law perspective, enroll on an apprenticeship, and there would be no breach of your immigration conditions. Now, leaving that to one side, it may well be that the program that you want to join, they may have their own conditions. So they may say, oh, we'll only allow those who are settled in the United Kingdom access to the apprenticeship scheme. Now, that's obviously a different matter. That isn't an immigration law concern as such. You're not breaching your immigration conditions by accessing the apprenticeship program. But if the apprenticeship scheme itself has its own requirements, own conditions, and if that prevents you from joining the scheme, that's another matter. Now, I don't know what some of these apprenticeship schemes actually state. If they state that you have to have indefinite leave to remain, I'd be surprised if it says that. But let's say it says you must have indefinite leave to remain to access the scheme, then obviously you would have some difficulty in accessing the scheme because you're not able to fulfill the conditions of that scheme. It's nothing to do with any restrictions on your visa in terms of you accessing public funds, which is preventing you from joining the scheme. So hope that properly answers your question. So I would say go for it, apply. If they request evidence of your status, provide it. If they come back to you and say, because of X, Y, and Z, we say you're not eligible, ask to see their scheme rules to see whether you fall within any other categories or not. But the starting point is, don't be concerned about your immigration status, any breach of your immigration status. Absolutely apply under that scheme, and let's see where you get to. To be honest, we do get asked these questions quite regularly. Can we access this? Can we access that? And I always say, look, when it says you're not eligible in terms of public funds, you can't apply for that. Public funds are defined, and typically there are benefits: universal credit, PIP, carers allowance, employment supporters allowance. There's probably about 15, 20 different types of benefits that you can't access. So hope that answers that question. Again, as I always say, I know we've got difficulty with calls coming through today. If you have any follow-up questions, concerns, please do get back in touch and I will try and address that. We're taking a short break. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. Normally, I'd say to speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Unfortunately, we do have some technical difficulties today, so I won't be able to take your call. But as always, you have the mobile number there, so please do continue to send your messages in on the mobile number which is there at the bottom of the screen. I do apologize for not being able to speak to you live on air. But please do continue to send your messages in. I will address your questions. Okay, we've had a number of questions coming in. Let's look at the next question that's come in. A question from my brother, looks like it's a question relating to refugee status. It says, Assalamu alaikum, brother. I had refugee status, had completed 5 years of that. Okay. I do apologize. In relation to my wife, she has completed 5 years of refugee status. She has been granted indefinite leave to remain a few days ago. She wants to travel to her home country. Can she go there on indefinite leave to remain status and then come back to the UK? So, wife had refugee status and wife wants to travel to her home country on her indefinite leave to remain. Can she travel on her indefinite leave to remain? Now, my view is that it's probably better not to travel to your home country where you've been granted refugee status. If you do need to travel to your home country, ideally you should wait until you've obtained British citizenship. So my advice would be try not to travel just on your indefinite leave to remain. Wait till you obtain a British passport. Then there are no restrictions whatsoever. Then you're eligible to travel on your British passport to your home country. My concern is that if you do travel to your home country on your indefinite leave to remain, there's always a risk that the Home Office may try and cancel your indefinite leave to remain if they feel that there's never any fear of you going back to your home country. I think the situation is different where you get your indefinite leave to remain as a dependent of somebody who has refugee status. But the way I read this question, to me, it doesn't look like. So the question is being asked about somebody who is a dependent of somebody who holds refugee status. It's put as if it is the person who wants to travel is actually the person who had refugee status and who has now qualified for indefinite leave to remain. Should they travel on their indefinite leave to remain back to their home country? And my view is that they shouldn't. There's no point taking a risk on that. Ideally, I think you should apply for British citizenship. Normally, you'd be eligible for British citizenship 1 year after obtaining indefinite leave to remain, assuming the good character requirement, which is where they look at your history for 10 years. There's no overstaying there. So I'd wait until you obtain British citizenship and then travel to your home country. Hope that answers your question. Now, if you're not sure, then do please come back to me and I will try and address that in greater detail. Okay, as I said, we're not able to take calls today, so please do continue to send your messages in on that mobile number which appears at the bottom of the screen. Okay, the next question that's come in, let's have a look at that. Question is as follows. I have lawfully stayed in the United Kingdom for 30 months on the 10-year route to settlement. Okay. I have an 11-year-old child. We've passed the English and financial requirements. What's the best option for my next application? So I have lawfully stayed in the United Kingdom for 30 months. It's about 2.5 years. I have an 11-year-old child and live with my husband. Pass the English and financial requirements. What is the best option for my next application? Now, there is one piece of information which is actually missing in relation to this. Now, you're currently, and reading into the question, you're the mother. You are currently in the United Kingdom on the 10-year route. I'm not sure about the status of your husband. If your husband is a British citizen or has indefinite leave to remain, so you're on the 10-year route. If your husband, if his status is that of British citizen or he's got indefinite leave to remain, then you can move potentially from your 10-year route to settlement into the 5-year route if you're able to meet the financial requirement and the English language requirement. I think that's why you're asking the question here or stating here, we have passed the English and financial requirements. Now, so if your husband has status in the United Kingdom, you're potentially able to move into the 5-year route. If your husband is in the same situation as you, that he is on the 10-year route to settlement. So both of you on the 10-year route to settlement, you might have got it on the basis of your child who's 11 years old. So if you're on the 10-year route to settlement, both of you, then the problem you've got is you can't move into the 5-year route in those circumstances. You'd have to remain under the 10-year route based on the child. So you would have to complete 10 years. Now, I know you're saying, well, look, we meet the English language requirement. It may well be that you've done the Life in the UK test, the B1 test in English, and both of you, you're earning well above the 18,600 requirement. But the problem is you don't fit in those circumstances into the 5-year category. So what is crucial here, what's important here, the bit of information which is missing is the status of your partner, your husband. If he's in the same boat as you, you're both in the 10-year route to settlement, then you are stuck in the 10-year route. However, if he is British or if he has indefinite leave to remain or he's got refugee status, then potentially, yes, you can move from the 10-year route into the 5-year route to settlement. It's the 5-year partner visa, like the normal visa that people get based on a marriage to a British citizen or somebody with indefinite leave to remain in the United Kingdom. So it all depends on your partner status. One of you, husband in this case, has to have British citizenship or indefinite leave to remain for you to go into the normal 5-year partner route. It's the normal 5-year partner route which requires the partner to have citizenship or indefinite leave to remain, or one of the other statuses which are acceptable. So hope that answers that particular question. Okay. Now, we do get a lot of questions at the moment about people who are interested in moving from the 10-year to the 5-year route, or somehow applying early for indefinite leave to remain. And there's a lot of stuff at the moment, and even on the internet and on Facebook, etc., where there seems to be a suggestion that anybody who's on the 10-year route can go into the 5-year route, and but it's not the case. There are only certain categories of people who can move, only certain categories of people who in this situation are eligible for indefinitely to remain earlier than the what the route normally requires, which is 10 years. Hope that answers the question. Okay, let's look at the next question. Question is, Assalamu alaikum, brother. I have applied for refugee travel document and they have told me it is currently with the caseworker. How long does it take when they pass your application to a caseworker? Essentially, the question is, how long do travel document applications take? In my experience, currently this is what I advise clients, that travel document applications generally take around 5 to 6 months at least for a decision at the moment. There is no quick turnaround. You might get lucky, you might get it issued quickly, but generally speaking, I advise clients that we are probably looking at getting the travel document back in 5 to 6 months' time. Now, it's not ideal. I understand. Sometimes people, when they've got their refugee status and they've been waiting for it a long time, they do need to desperately travel. What I would advise is that, look, if your circumstances are exceptional, if they're compelling, then let's say somebody's ill in your home country, parents are ill, you need to travel, and get medical evidence of that, forward it on to the caseworker, or get your MP involved, get your MP to forward it on to the caseworker to try and get a quicker decision. It might work. There's no harm in trying. If there are exceptional, compassionate circumstances, then put it to the Home Office, maybe through your local member of parliament, and try and get the caseworker hopefully to look at your application quicker than normal. But generally speaking, in a normal application, you are typically looking at 5 to 6 months at the moment before you get a decision. So it is taking a while for these decisions to come through. With all cases, I mean, I think the worst affected cases in terms of delay, in terms of processing time at the moment, I think the worst affected cases are the human rights type applications which have been submitted. On those who are familiar will know the applications are sometimes submitted on form FLR-FP. Literally, they're taking 12 months, 13 months for a decision to come back. I mean, they're the worst affected. A lot of the other applications aren't too bad. They seem to be being processed within a reasonable timescale. But obviously, there is still a bit of a backlog in certain departments, so it is taking slightly longer. Brilliant. We're taking a short break. Inshallah, we'll be back in the next couple of minutes. Inshallah. See you then. Assalamu alaikum. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. To send us a question regarding any English legal matters, please do send those questions in on the mobile number which appears at the bottom of the screen. Apologies to our viewers who've been trying to get through to us live on air. We do have some difficulties with our lines today, so I'm not able to take your calls, but please do continue to send your messages in. Mashallah, you've been sending loads of messages in and I am going through them. If I answer your question, you're not sure, please do send another question in straight away and I will see that live here on air and I will address that. But I do apologize if you've been trying to get through and you've not been able to get through today. Okay, let's look at the next question. Immigration law question. Looks like it's relating to the timing of when applications are submitted. And the question is as follows. How strictly is the 14-day rule for making a further leave to remain application applied? What if I am late by 1 day? What if I make the application on the 15th day? Is there any chance to have this overlooked? Now, the Home Office is now very strict in terms of submitting applications. So the starting point is this. Okay? You know, when you have a visa already to live in the United Kingdom, so you've got your leave to remain in the United Kingdom, and that's coming to an end, you should really make sure that you do apply in time. So let me give you an example. If your visa is coming to an end on the 1st of April, and if you really want to push your luck, the last day on which you can apply is actually the 1st of April. If you leave it to the 2nd of April, you're an overstayer and your application is a late application. So you should try your best to get the application in on time. And the last possible day on which you can apply is the last day of your visa. So in the example that I've given you, if your visa comes to an end on the 1st of April, that's the example, I say apply much earlier, but worst case scenario, you should apply by the 1st of April. Now, if you apply late, you have to have a very good reason as to why you're applying late. They will give you 14 days to apply. And if you have a very good reason for applying late, but within those 14 days, then your application hopefully won't be considered as a late application. So if your visa's coming to an end on the 1st and you've missed it, that 14-day grace period would be the 15th of April. Now, so if you delayed and you apply anytime up to the 15th of April, and you have a very good reason as to why you weren't able to submit that application, then the Home Office is likely to accept it as an effectively like an in-time application, treat it as if you've applied in time. So in that scenario, the first thing is you must apply within 14 days of your visa expiring, and you need a very good reason as to why you haven't applied in time. So it could be that, let's say, for example, you were unwell, you had COVID, and you've got the NHS note from the NHS website confirming that you've been advised to stay at home. That could potentially be a good reason as to why you didn't submit your application in time. So the starting point is you must try and submit in time. If you haven't, potentially you've got 14 days, as long as you've got a good reason for the delay, to get your application in and for that application to be considered as an in-time application. So that's a typical scenario. Let's say you've submitted an application in time and it's been refused. You still have the opportunity to reapply. Now, in that case, you do have 14 days to reapply. So you've applied for an extension, a student extension, for example, that's been refused. In the meantime, you've got married and now you want to apply on the basis of your marriage. When you get the refusal, you don't have to apply the next day. That would be unreasonable, too difficult for you to do. They do give you 14 days from a refusal that you receive to reapply. And again, you have to make sure you get that application in within that time limit for your new application, your latest application, to be considered as an in-time application. If you leave it late, you run the risk of your application being considered out of time, your application being considered as if it is being made by an overstayer, which is extremely problematic for you. So there are cases where, had you made the application in time, it would have been successful, but because it's been made late, you're considered as an overstayer. You don't fulfill one of the main requirements of that visa category that you want to go into, which is your status is that of an overstayer. You don't have leave to remain, and therefore you don't fulfill the requirements of that particular category. So overstaying can be extremely problematic for you. Now, your question was, how strictly is it applied? I would say it's applied extremely strictly. In my experience, I've only come across a handful of cases where we've gone beyond that date. In the example that you give, the application hasn't been made on the 14th, but it's been made on the 15th. We've submitted quite exceptional documentary evidence, as to why the person wasn't able to submit the application in time. They were in hospital or they were seriously unwell, and they've managed to somehow get the Home Office to accept it as an in-time application. But I would work on the basis that generally, if you apply more than 14 days after your visa has expired, you should work on the basis that the Home Office will not accept your application as an in-time application. But thank you very much for that question. Now, again, this is an issue that arises quite often, and it's one of those where if you do get it wrong, it can be seriously problematic. So please do keep an eye out on expiry dates. Next question that's coming looks like it's to do with a spouse visa where things seem to have gone wrong. Let me read the question out. My friend here is in the United Kingdom on a spouse visa. She will complete her 5 years next month, but her husband has refused to support her application. He's not provided the documents that are needed. She has a 3-year-old child. She has her name on the property. Okay. Her child lives with her. What are the options for her in terms of the extension and in terms of the property? She hasn't been to the police to demonstrate or to report any domestic violence. Although she has faced domestic violence, she can't prove it. Now, there are a couple of different potential outcomes here. Your friend has completed 5 years in the United Kingdom under the spouse visa route. Now, the reality is this, that if the husband does not support the indefinite leave to remain application, she can't get indefinite leave to remain under the spouse route. I think you understand that the spouse route, the normal partner route, requires the husband to support the application, whether it's for an extension or whether it's for indefinite leave to remain. So if the husband isn't prepared to support the application, your friend is unable to qualify for indefinite leave to remain under the partner route. Now, that leaves your friend with two options. One is to apply for an extension based on the child. Now, I'm assuming the child is British. You've already said that the child lives with your friend, who's now looking at extending or applying for indefinite leave to remain. So on the basis of the child living with her, on the basis of the British child living with her, she would be eligible for an extension under the parent route. Now, she wouldn't have to meet the English language requirement. She doesn't have to meet the financial requirement. The fact that the British child is living with her would be enough for her to be eligible to apply for a parent visa. So option one, assuming the husband does not support her application for indefinite leave to remain, option one is for her to extend her visa based on the child who lives with her, and the route is the parent route. And that doesn't require any English qualifications. It doesn't require finances. It doesn't require savings. It doesn't require any evidence in relation to accommodation. It's simply based on the fact that she, your friend, is looking after, has sole responsibility for a child that is British. That is sufficient in itself for her to be eligible for an extension. So that's option one. Option two, I think, is more difficult. And you've alluded to option two in your question. You've said that she has been the victim of domestic violence, but you've said that she has no proof of that. The difficulty with a domestic violence application, the advantage is that if she has proof of domestic violence, she would be eligible for indefinite leave to remain straight away. But that's the advantage. The problem is that you need evidence of domestic violence. And without evidence, I think she might struggle. Normally, the evidence would be medical evidence, police evidence, an injunction, etc. If there's none of that, she might be in difficulty. She might be able to get the assistance of social worker, go to a refuge, etc. And they may be able to do an assessment and say she's a victim of domestic violence. That may work. But I think Without that, without any evidence of domestic violence, I can't see how that application for indefinite leave to remain based on being a victim of domestic violence would work. So option 2 may be problematic. She might have to look at option 1, where it's not great. You don't qualify for indefinite leave to remain, but you do get leave to remain in the United Kingdom. And after another 5 years in that route, and after 10 years of legal residence, 5 years under the spouse partner route, 5 years based on looking after the child, after completing 10 years in the United Kingdom, she would be eligible for indefinite leave to remain at that stage. So option 1, based on the child, it's certainly an easy option which is available for her. Option 2, based on domestic violence, may well be problematic and may not be that easy. Hope that answers that question. I do apologize again for all our viewers who've been trying to call in today and speak to us live on air and not been able to get through. I do apologize for that. But thank you very much indeed for sending your questions through. Inshallah, we'll be back next week at the same time. See you then. Assalamu alaikum.